Good afternoon, dear friends. We start our event. This will be a presentation of the report Crimean Process, Problems of Compliance with Fair Justice Standards in Politically Motivated Cases. Our guests are Mykhailo Batrak, coordinator of the initiative Crimean Process, Serhiy Burov, executive director of the Educational Human Rights House, and Chernihiv Ostaf, expert of the Resource Center for Human Rights from Chisinau, Moldova. Svyrydova, lawyer of the Ukrainian Helsinki group, Ilmi Umerov, deputy head of the Mejlis of the Crimean Tatar people, Yasenovska, president of the Kharkiv Regional Foundation Public Alternative, and moderator is Tetyana Pechonchyk, head of the Human Rights Information Center. Tetyana, you are given the floor. Thank you, dear colleagues. Welcome to our presentation. Before starting it, I would like that we all commemorated the victims of Kerch, all those children and adults who perished in this tragedy, with a minute of silence. Thank you. So today, we have the opportunity to present the results of work that was ongoing for 2 years. And this is the attempt to analyze the first report concerning the analysis of the right of fair justice in Crimea in politically motivated cases. And this is based on visiting the court hearings by monitors, and this analysis is based on the visits to 174 court hearings in 9 political motivated cases, and the conclusions of our group, whether those courts that work in Crimea, do they provide protection from persecutions, or they add to these persecutions. So the group of experts worked on this case, the representatives of 6 organizations from Ukraine and Moldova, and our colleague from Moldova organization joined, and he will have the opportunity to tell us about his impressions from this work. Now I give the floor to a person who didn't join our panel, Ms. Helsinki, a Czech Republic embassy representative, and this embassy provided help in preparation of this report. And one more Czech organization also joined us in this work and helped us. Thank you. Good afternoon. So I will speak Russian. Thank you for this opportunity to represent Czech embassy here. And first of all, I would like to thank the Center of Information on Human Rights and the experts and all other individuals for this unique material about the access to fair justice in Crimea. We are really happy that Czech Republic is helping to spread this material, not only among Ukrainians, but also to provide this material to international community. Also, about the discussion that will be ongoing, I would like to stress that we and our colleagues from EU countries, we do not forget about political prisoners in Crimea, and we call on the Russian Federation once again to release these people. We believe that neither annexation nor political persecutions, they should not be in the Europe of 21st century. And we have the opportunity to have one of the heroes of these processes, Ilmi Umerov, and unfortunately we do not have here others of such as Vladimir Balokh, Suleiman Kadyrov, and Igor Mavankov. I won't mention everybody because unfortunately now this list is too long. But I hope that the spread of the information about violations of rights and the recording of these violations, that will help in the future to all those people who, because of their views, are unjustly imprisoned in Russian prisons. Thank you for your work, for the work of your country. And we all try to help in release of our political prisoners, all those who illegally deprived of their liberty and now are in prison in the occupied Crimea or in the territory of Russian Federation. Now I would like to go back to the presentation of the report, and I give the floor to Daria Svyrydova, lawyer of the Ukrainian Helsinki Human Rights Union, and he is going to tell us about the main goals and the main conclusions the group of experts reached while preparing this report. Good afternoon, dear colleagues. Thank you, Tetyana. Thank you very much for your attention to this important topic. And on the whole, as the organization that from the start of occupation deals with the documenting of human rights violations, for us it was important that people have access to fair trial, and this issue of fair trial in the condition of occupation, this is the important indicator of observance to human rights, and this tells us about the situation with human rights in the armed conflict. We hear a lot during these years that there is no fair justice in Crimea. People are persecuted without any grounds. And the group of experts saw that now there is no proper research based on facts, on observations and analytical research that would provide grounded arguments why we may say, or we may not say, that in the territory of Crimea there is or there is no efficient and fair justice against persecutions. And the aim of our research and the task of our research is to carry out such in-depth analysis. And the task was to answer two questions. The first one, whether the court system created in the condition of occupation of Crimea provide proper justice against unlawful politically motivated prosecutions, and the second one, the assessment of fair justice in the courts based on the examples of politically motivated processes. What is important is that the subject for monitoring, we had some limitations, some tasks, some resources and sources of information that were the basis for our research, and we had some limitations in our research, and I would like to tell about them briefly. And as my colleague said, we analyzed 174 court hearings, and there was direct observation, and in 2 years of our research, and it is limited the start of 2016, and we end our observation in September this year. So nearly for 2 years we were our monitors observed court hearings in Crimea, and on the whole we attended more than 300 court hearings, and 174 were included in our research. For our work, we selected 9 court cases, court hearings in 8 cases, and you may see it in our report. And we did it according to our criteria. We had 8 cases, the cases of Vladimir Balokh. In this case, there was a monitoring and during 2 court hearings. Also, Ilmi Umerov case of 26th of February. Several people involved there. And Pechonchyk case Mykola Semina case and the case of Yevgen Panov, subverted case, and the case of Suleiman Kadyrov, and the case of Igor Mavenko. So we had some criteria to select those cases, and you may find the information about the criteria used by our group, but these are the cases where we observed serious violations of human rights and evident political motives of persecution of these people. And also the motives of persecution that are not declared by occupation power, and such as the limitation of freedom of speech or interference in peaceful gatherings and other motives. Also, we had some other criteria to select cases, such as in all the cases we carried out observation of 30% of court hearings in each of the cases, and in each cases we have enough information that was voluntarily provided to our group by the participants of the court hearing or was in the open access. One more important argument for us was that all these court hearings, they were held in the territory of Crimea that is occupied. And what is also important, on the whole, we analyzed 174 questionnaires, and the methodology that was used by trained monitors. They used methodology of OSCE, and we used the information that was also outside the court hearings. We analyzed about 70 sources of information, different analytical materials concerning court hearings in Crimea, including these 9 court cases, and also mass media outlets that contained some expressions of public figures or representatives of occupational authority concerning those cases and court hearings. About the structure of this research, you may see that this is based on detailed methodology, and you may find information about the methodology of our research and how we reached the conclusions and what we used while preparing this research, and also overall recommendations and conclusions. And we created first the hypothesis whether the court in the in occupation may correspond these standards, and we had 4 standards in order to analyze this, and also the recommendations to Russian Federation, recommendations to Ukraine based on the result of the research, and the recommendations to international community. So several words about the limitations that we faced in our research. This is important to understand. Maybe these questions may arise, and we limited the information. We used information only from open sources and from the participants, and the information we got during court hearings. Because we had a lot of information and we had to make this in-depth research based on facts, we collected the materials and we understood that we should focus our attention only on 4 aspects of fair justice. This is so independent court, and the court created based on law, public hearings, and presumption of innocence and equality of arms. So these are the 4 aspects we focus our attention on in our research, and these 4 standards were analyzed in these court hearings. So our report does not contain the analysis of all violations of human rights, international humanitarian law. In these cases, the focus of our research was the research of these court hearings and separate standards of fair trial. At the same time, it is important to understand that we focus our attention, as the standard says, according to European Convention, on procedural issues, and not on the essence of conviction or the court hearings or the verdicts of the court. So I may only say one important conclusion at the end of my speech. So my colleagues will tell you about separate standards and what we observed, and they will tell you about our conclusion. But the main conclusion our group reached is evidently, and this is based on confirmed by our research, the court that is created in occupation cannot provide proper protection in politically motivated cases that we studied and in other similar cases. It is evident that one of the first conclusions we've reached, that the fact of creation of courts in occupied territories in violation of the norms of international humanitarian law and the procedure of appointing the judges and the procedure also rejected some basic principles, and the system was created that didn't provide the opportunity to select proper judges, and the judges were not able to deliver justice based on the Ukrainian law was not used during these court hearings. They used the law of occupying state, and also our observers have shown that these laws cannot provide fair justice, and they cannot administer justice in the right way. And we also took decision based on the conclusions that that despite the standard is evident and it was not observed, we continued to study several other standards in order to have grounded results. And the main the idea of our hypothesis, to realize our hypothesis in this research, to confirm or reject it. And there are bright examples of violations of the standards in our research that our monitors found out during court hearings. Thank you, Daria. And as it was said, we analyzed the adherence to the right of trial and the adherence to four standards. One of the standards is the presumption of innocence, and I would like to and Maria Yasenovska, president of Kharkiv Regional Foundation Public Alternative, I would like her to tell us about this standard, about the presumption of innocence. First of all, we saw that there were a number of facts that created the image of the guilty. In the Balogh case, he was put in a cage during all hearings, and there are several decisions of European Human Rights Court, and these decisions say that the putting people in the cage is the violation of the presumption of innocence, and it creates the image of the guilty person, and it also violates Article 6 of the Convention. And also our expert group also believed that this aquariums, so-called aquariums, this is not they are not efficient. And in the aquariums, in these security cages, they put also some people during court hearings. So mass media played a major role in creation of a guilty image of the person involved. And some officials, local officials in Crimea, and that was a case. And Aksionov, in Evgen Panov case, he commented the events of this hearing, and he said about some hypothetical saboteurs. So he said that these saboteurs are killed and strung up on the border in order to discourage the others and let them know that no one is allowed to threaten the lives of civilians and soldiers. So this is the direct call for destruction of those people whose guilt is not confirmed, and the participation of these people in some acts is not confirmed. Also, I would like to note that in the number of cases, there are grounds to believe that there was the violation of consultation, room right, and there was some strengthening of convoy, and the number of police officers was increased. So people were on the day of the verdict, people in the near the court, they had the proper car to bring these people to jail, and so they knew from the start what the conviction this person get. So maybe this is all. I'm ready to answer your questions. So the main recommendations in this section. So whether it is a Russian or court of other court, there are standards that should be observed without. So it should be based on the work of the court should be based on standards in any country. So now I give the floor to the representative of Chernihiv Educational Human Rights House, Serhiy Burov.
Good afternoon. The principle of equality of arms in the conditions of occupation in Crimea, whether the court could undoubtedly be fair and provide fair trials, ensuring or risk mitigation that the court will be used as a tool in politically motivated cases. The principle of equality of arms is important, very important, but in the course of our monitoring, we found many cases when the parties were not equal. I mean, the defense didn't have the equal rights. In many cases, the accused was not present at the trial sittings. In the case of Pechonchyk, 70 court sittings were attended by monitors, but he was not present at them. This is 44% of the whole number of sittings in the case of Pechonchyk. The second principle of participation of the accused means that he should be present, he or she should be present and also heard. In the case of Vladimir Baluch, the right to be heard in his final speech means also the right for to be heard. Before the court sitting, he didn't know that he will be pronouncing his final speech, so he hasn't prepared to this speech. As concerns equality of arms, we monitored and considered whether the defense party had the opportunity to get access to witnesses, to listen to the evidence, and to get written evidence. And there are many cases, unfortunately, where the requests of the defense to get written proofs, written evidence were rejected, and the witnesses often didn't attend the sittings, and the defense requested either the presence of those witnesses or provision of the written proofs, but the standard was very often violated while the prosecution party, they were ensured with all those opportunities. The prosecution had privileges, such as before the interrogation of the witness on the prosecution party, the judge asked him to read his testimonies, saying that maybe he could have forgotten his witnesses. The defense often asked for engagement of experts and their opinions. In one case, there was a rejection to provide portrait expert opinion. The judge said that it is not necessary, but it was important for the defense in order to formulate their state. In Mykhailo case, the request was rejected. The court rejected because the witnesses were located in Ukraine. That is why they were not summoned. Very often, the court used testimonies of anonymous witnesses, but although it is possible, but the standards, including European court standards, if anonymous witnesses' testimonies are used, the equality of arms should be preserved, and the defense asked many times to provide anonymous witnesses' evidences, testimonies to those representatives of defense. And different conditions were also considered, for example, the judge's behavior or the arrangement of parties in the courtroom. There were two facts in Akhtemchyg's case, as he was not present at the court sitting. The presence of Tenschygos in the courtroom is doubtful. He was in the detention center, which was at 10 minutes distance of the court location, but he was not present in the court, while Baluch was brought at the distance of 140 kilometers.
So there was loud communication, and everyone could hear the speech even in the corridor. And the second example, there was one example of the behavior of the judge when the witnesses were heard, the witnesses of the prosecution, and the judge reminded and explained to the defense party what these witnesses meant when they said something. So it was evident that the judges were on the side of the prosecution. So, and our recommendations about the equality of the arms. And one more example I would like to mention, statistical one, about the inequality of arms. 81% of petition of defense, these petitions were rejected at the same time. About 80% of petitions of prosecution were taken by the court. And our recommendations and conclusions, these are, first of all, So there should be presence of the defendant during court hearing. There was proper access to evidence of the witnesses, both oral and written, and also the situation should be more equal for prosecution and for defense if there are anonymous witnesses, and also there should be a rejection of the practice of rejection of these petitions. So this party should be equal. There should not be a preference to the prosecution. So one more standard we have analyzed. This is the public hearing principle and access of monitors to court hearings. And I would like to speak and comment on the public hearings principle. And we now give the floor to our colleagues from Moldova. So when we are speaking about court hearings, we should say that without it, there is no public trust to the courts. So all the interested parties and the public, they should have access to all the stages in order to see what is going on in justice, and that we have the trust in the process, and we may see 3 stages. So there should be proper access to this standard before, during, and after court hearings. So if we are speaking about the first stage, international standards say that there should be proper information about court hearings, the date, the time, and who will participate in those hearings. Second, there should be access to courtroom and the building of the court. Even if people do not want to take part in the court hearings, people should have access to the courthouse, and so this is before the court hearings. And the publication of detailed information about court hearings in all the cases, and in Baluch case and Mavenka case, in nearly all the cases, practically without exception, this information was not published adequately, and this had systemic character. It was done repeatedly and in many cases. So this is some level of systemic violation of this aspect. And access to courtroom, also in many cases it was not observed. So, and about court hearings, there are 6 or 7 requirements to the process. We may select the most difficult ones. The participation of the public, to be present during court hearings. In 3 out of 9 court hearings, there were some barriers of administrative character, lack of space in case of Umerov and in case of Chegos, and in the case of 26th of February, this was monitored and recorded, and also the opportunity for journalists, monitors, and the public to record. In Baluch and Mavenka and Semina and Umerov Chegos case and 26 February case, this right for audio taping to turn on the phone and record, this right was not observed, and also the party of defense requested officially for this right to audio tape, and in some cases this was rejected officially by the court. This is a grave violation of the principle of public hearings. And also there was weak acoustics and people who were present in the hall sometimes. The process was done in such a way that people could not hear one another, and people didn't have the access to information, and these are the main aspects during court hearings. And in the report you may see other aspects that were violated. And what happened after court hearings? So the verdicts were made and decisions were provided. Usually the standard is rigid. The decision should be published in full, not only the resultative part, but the whole conclusion should be published. But practically in Balukh case, in Mavenka case, and Panov case, in Semenan Chigoz, and 26th of February case, this decision was not published in full in the first instance and in the appellate. In this way, people, the public, they cannot get information about the motives, and this is a grave violation. So I would like to provide a conclusion also about our monitoring. We saw the repeated violations of the standards. These are not isolated cases. We may say about systematic nature of violations in these cases and in other cases, and we may come to conclusion that in all cases there were such violations, and in some cases we saw that those norms, some norms do not correspond to international standards, and also about the publicity and public character. And maybe about the second hypothesis, we tried to resolve whether, so not all the cases are politically motivated, and the prosecution and the investigators, they provided to establish some. So the courts were not efficient in other cases as well, we believe, and there are indicators, in direct and indirect, that the courts, they create the system that aggravates political motivation of the cases. And in the stage we saw that in order to provide full answer to this question, we should study the essence of each case. We may look whether there is a strategy of prosecution. Maybe it was weak, but the courts corrected the mistakes of prosecution and provided positive interpretation of all evidence of prosecution. But for this, we should look all the case through and look into the essence of the case. For example, there was no proper grounds for sentencing the person, but the courts contributed to the benefit of prosecution. So we understand that this would be an important result, and there are signs that courts played an oppressive role and played to the benefit of prosecution, and we believe that we should carefully consider this and to get proper final conclusion on this. So this is about public hearings. So we thank our experts, the authors of the report, and as it was said, one of the main sources for the analysis was direct monitoring of the processes and hearings. So this report is based on 147 visits to the court, and Mykhailo Batrak is one of the monitors, and he is here with us today, and I would like to give him the floor. And he represents the Crimean Process initiative in order that he provide his views on these visits and what conclusions he made on this.
Afternoon, I will be talking a little bit less than my colleagues because I was not an expert who was one of the authors of this report. I am from Crimean Process Initiative Group. During monitoring, we monitored more than 300 court sittings, and 174 court sittings were used in this report at the foundation. All data which my colleagues was out to date, they were heard and by us and documented. Serhiy told today about the percentage ratio of satisfied and unsatisfied requests. of the defense. Most the requests of the defense concerned how the witnesses' testimonies which were heard without the witness presence. The defense asked for the research into the proofs, into the evidence about the interrogations of witnesses, but they were rejected, while the prosecution witnesses' requests were satisfied. Did you have any problems with access to courts as the monitors? Did you feel there's prevention? There were no direct pressure in courtrooms and with access to court buildings. We had access to court buildings, but there were some cases of, for example, detention while crossing the border and so on. All visitors, all monitors who visited court had their passport details documented somewhere. We didn't know for what purposes. Ilmi Umerov is present here today. He is a deputy head of the Mejlis of Crimean Tatar people. And fortunately, we had Pechonchyk and Ilmi Umerov freed. They were released and they are on mainland Ukraine territory now. I would like to ask Ilmi Umerov, did you expect from the court any fair trial? And what do you think about the monitoring results? Did you have time to see the results of the monitoring and the report? Good afternoon to everyone. I will start with the second question. Unfortunately, I saw the report only today. So I didn't have the chance to read the text prior to this briefing. I think monitoring of situation is necessary and monitoring data should be presented, submitted to authorities in Ukraine so that they use this data for preparing the occupation of Crimea, because all of us are fighting for returning Crimea to Ukraine and restoring Ukraine's territorial integrity, and including Lugansk and Donetsk region areas which are occupied. They also should be released. To have arguments, we need relevant information, which top officials. So top officials should be should be members of your monitoring teams. This is necessary, I think. And this concerns your case. What do you think about trial? Was it fair? There were no fairness, and we didn't expect any fair trial in Crimea. I can say responsibly that in the Russian Federation, including the occupied Crimea, there are no fair courts. All of them fulfill the assignments of their regime via Federal Security Bureau of Service. In my case, the judge was very behaving in very diplomatic manner, but at the final, the sense where, like we expected, the prosecutor wanted the probation, while the judge issued the guilty verdict of enjailment. So the judge's verdict was more severe than the prosecutors asked for. So we cannot speak about any fairness of trial in Crimea. Now we shall start the round of question and answers. I would like to share our plans. Today we present our report here in Kiev, and we have already prepared the translation of our report, and we shall be presenting this report in Brussels next Wednesday. We think this report will be of interest for the United Nations and the Council of Europe and other international institutions. We had the opportunity to meet the representatives of UNHCR mission to Ukraine, and they saw the analysis whether the fair trial standards are complied with in the territory of Crimea. And now we are ready for your questions. Please introduce yourself and ask your questions. Good afternoon, Stas Kozluk, Ukrainian Week. The defense asked for the prosecution's witnesses, evidences. So there was no excess. We would like to hear your evaluation whether the lawyers in these cases could make some balance in the situation. For example, thanks to the lawyer Parashutkin, one rapist was issued unguilty verdict. And whether the lawyers are safe if they take part in these cases, just like the monitors. We know the cases when Federal Security Service visited lawyers and monitors. Thank you. As concerns the role of lawyers, it is very important in these cases which we analyzed. They were analyzed thanks to professional activities, thanks to professionalism of the lawyers. And if the lawyers do not raise the issues, for example, when defenders asks for not using cages or security cages in courtrooms, again the defendants no request was allowed. And talking about guarantees of fair trials, we tried to see any positive trends, whether at least some standards were complied with. Unfortunately, in general, the trends were negative. The lawyers' activities are important anyway, and yes, it is hard to work there. Lawyers experience difficulties. Courts in Crimea not just are non-consistent with the standards. We saw that the courts take the role of prosecution, and in some cases there were just elements of oppressive mechanisms. In the cases we have these examples, in this section of the court appointed on the basis of the law, at least in 3 cases. The sentences were more severe in the case of Igor Mavenko, Ilmi Umerov than the prosecution asked for. And the picture in here in Artemchik's case, we saw a very grave situation. Ms. Povetidi didn't answer the question. They not only didn't answer the question, but also she commented and the court ignored this behavior of these witnesses of the prosecution, and the court rejected every motion of the defendants. Of course, this complicates the work of lawyers when the court ignores the motions and the requests of lawyers. But this was not the focus of our research. You can read the report and see in what conditions the lawyers work in Crimea. Now we are preparing some papers as to the lawyers' activities in Crimea, and these independent lawyers who work in politically motivated cases. There were many facts when the occupational regime made pressure on them. The most striking examples are about the lawyer of Emil Gamudinov case. He was arrested for 10 days, so he could not defend in many cases his defendants, and in Ilmi Umerov case, the lawyer could not professionally work because he was made a witness. But it was not the focus of this study. I'd like to add that lawyers, they fulfill very important role, and they keep higher standards of the trials, but our research demonstrates that in politically motivated cases in the territory of the Russian Federation, even where lawyers are ideal and their activities are ideal, does not mean that the verdict will be issued with consideration of all these lawyers' efforts. If there is a political order, then nobody can influence. We should not be in illusions. I'd like to add.
So it's about whether the lawyers can balance the situation, to observe the legislation. No, they cannot do this. Not in the territory of Russian Federation, nor in Crimea. We need the lawyers, the defenders, they just monitor the situation. They can provide information about violations of rights of the accused person. And they are needed in order to have the contact with political prisoner. In order to have this contact, because sometimes relatives are not enough for this. They do not have proper qualification and so on and so forth. So defendants, they are in danger, and I had 4 lawyers, and all 4 of them were pressured And maybe you know about one lawyer who was deprived of his license. He was my lawyer, and the process has only started, and there were the meetings of Presidium of the Moscow Collegium of Lawyers, and they wanted to deprive Mark Fagan of his license, and one witness was summoned. He was not summoned, but he was seized. People took the person and brought this person to Republican FSB office, and in 3 or 4 hours they tried to get some evidence, and this person rejected it, and he said about the article of the Constitution, and Polozov became the witness, and he provided information during court hearing, and they were I do not know whether they reached their aim. He did more than the lawyer did. Emil Kurbedinov, for repost of some publication in social media in 2013. I stress this, 2013. This was before occupation. He was given 10 days of arrest, and Mr. Semidlaev, tax officials came to him. I do not know how they are called now, these officials, and they accused him of some illegal hotel business, and he has 4 children and a small house, and he didn't do any business, but they wanted just to get into his house. So there are such instances, and these things happen also with other defendants. So do you have other questions or comments? If you do not have questions, I have a question to the authors who work on this research. So this research is ready, and what is the final goal? What influence it should have, and what recommendations you formulated in the resolution part? What are the main conclusions?
In fact, what important to understand that starting working on this report, yes, on the territory of controlled by Ukrainian government, also the standards of fair trial could be not complied with. The same concerns the territory of the Russian Federation. So whether the fair trial could be effective in protecting civil rights in the occupied territories. This was the focus of the report and our activities. We see also development in future of this research, negative conclusions that the courts are using Crimea as an oppressive mechanism, and our research demonstrates the violations of civil rights. There will be our new report, and we will be glad if the defense will use these reports as well at the national and at international levels, and in applications to ICHR as concerns violation of Article 6 of the Convention on Human Rights. We have the long list of recommendations to the Russian Federation. The first is saying that the Russian Federation should ensure compliance with the provisions of international humanitarian law in the administration of justice in the territory of the Crimean Peninsula. For example, we understand that some standards cannot be respected in Crimea because the composition of courts has already been changed.
So we have several recommendations to Russia, a number of recommendations to Ukraine, and we will send them to proper government bodies and law enforcement bodies. And our group came to conclusion that here there are also military crimes, and we may say that in some cases we may say about deprivation of the right for fair trial of people, and it is important that the results of this research were used in advocacy, and we should not only speak about this and make some political declarations and statements. We should operate with proper data, and our monitors got a lot of information from the field, and it testifies those violations, and these facts should be brought to international community and also to Ukrainians, because many Ukrainians do not understand what is going on in the occupied territories. So if you do not have other questions, this is the end of our presentation. Thank you for your attention.